Well, we are a little bit behind, but let me, uh, Tony, yes, and Peter,
Judge.
Michael, we'll need one extra chair here. Thanks. Well, I think we are ready to go. Let me welcome you here. Good morning. My name is Paulo Sotero. I'm the director of the Brazil Institute at the Wilson Center. We have an excellent program this morning on the rule of law, and Minister Dias Toffoli is in town visiting and will give us the honor of opening a series that we will continue discussing issues related to the rule of law. We think it's a very positive story for Brazil amidst a moment of challenge, of crisis. I will later call Ambassador Tony Harrington to introduce our guest of honor, Minister Dias Toffoli, but before, and also Judge Peter Massetti, who has been our partner, my partner, in trying to promote Brazil-U.S. judicial dialogue for many, many years. We started actually when I was a correspondent here for Estado de São Paulo about 20 years ago. But I would like to take this opportunity to invite my dear friend Ambassador Figueiredo to say a few words to us. Actually, by coincidence, I think Ambassador Figueiredo is now leaving, already being named to be the next Brazilian ambassador to Lisbon. But so this should be probably his last public appearance maybe in Washington, but the first one was here also when he arrived in 14. We had a very important event here on a very complicated current matter, which is the hydrological equilibrium of the Amazon basin. This is a very serious issue. And we had then the Secretary of Energy of the United States, Ernie Moniz, and the president of the São Paulo Science Foundation, the former foreign minister, Celso Laffer, here with a team of experts to debate that issue. Ambassador Figueiredo at that time gave us the honor to also open the event. So I would like to invite him to do it again and come to the podium and say a few words. Thank you very much.
Thank you very much. Good morning. I would first like to thank the Wilson Center for hosting this very important event. And it's a Brazil Institute. And Paulo Sotero, my friend, for inviting me to be here and having the honor and the pleasure of welcoming Minister Dias Toffoli. I will not make a long introduction of Minister Toffoli because my friend Tony Harrison will have the pleasure of doing that, but I would like to say that Minister Toffoli is a good friend, and he is one of the youngest justices to be appointed to the Supreme Court in our history. He's a member of a new generation of law practitioners in Brazil, and a generation that, well, being myself a lawyer by training, it is a generation that we are very proud of. And a generation that is transforming our judicial system and modernizing it. So I thank you all very much for being here, and I am sure that you will agree with me about the importance of this man that we have here today and what he is doing for the good of the country. Thank you.
Just two final things before calling on Ambassador Harrington to speak. First, we are live webcasting, so I'd like to welcome those who are following the proceedings here. They are mostly in Brazil, but not only. Also, to let you know that the lecture by Minister Toffoli and the summary of questions and answers, etc., will be published by the Brazil Institute. It's our intention also to publish in a series all the future events on this series on rule of law. With that, I would like to invite our chair of the Brazil Institute Advisory Board, my dear friend, Ambassador Anthony Harrington, to introduce our guest of honor. Thank you.
Paulo, you can rearrange the chairs. So you have a seat. Good morning, everyone. Welcome to this inaugural event in a series on the rule of law in Brazil, launched by the Wilson Center Brazil Institute and the Washington College of Law at American University. We're flooded with lawyers today. I just realized Judge Massetti, Justice Dias Toffoli, myself, and now the ambassador confessed that he's a lawyer as well. So we, like you, are interested in the subject of the rule of law around the world. It's very important and a particular time of importance for Brazil. This collaboration really began about 5 years ago with the Brazil-U.S. Judicial Dialogue, which the Brazil Institute co-sponsored with the Law Library of Congress. This important and timely initiative owes a lot of credit to senior U.S. District Judge Peter Massetti of Maryland. Judge Massetti was a Peace Corps volunteer in Brazil a few years ago. And like many of us who spend time in Brazil, he has remained involved and for years has worked to foster dialogue among judges, prosecutors, and legal experts from both countries. While I was ambassador, Peter was involved in supporting the introduction of judicial precedent and discretionary review, which I think has taken an increasing place in the judicial practice. We'll hear more from the justice on that. Peter, thank you for your continued service both here in the U.S. and in Brazil. I would also like to salute Brazilian Ambassador Luiz Alberto Figueiredo, a distinguished diplomat, a friend of mine and of the Wilson Center. As Paulo noted, he's headed for the new and prestigious post of Brazil's ambassador to Portugal. I don't know if we would call that the home country or not, but I remember when I was appointed ambassador to Brazil, the Brazilian ambassador, the U.S. ambassador's wife in Portugal called me and said, "You're going to love Brazil. Even in Portugal, everyone really loves the Brazilians." So we wish you well and thank you for your service here in Washington and hope to remain in touch. Our speaker this morning, Minister José Antonio Dias Toffoli, is a very busy man these days, as are his 10 colleagues on the Brazilian Supreme Federal Tribunal. They are central figures in this time of political, economic, and institutional challenge in Brazil. Also a critical time for affirmation of the rule of law in Latin America's largest democracy. We who are friends of Brazil, of course, lament the serious challenges which the country and its people are experiencing and support the work needed to get things back on track. Breaches of the public trust reached a disturbing level, but on the other hand, there's good news as well, and that is that the judicial, prosecutorial, and law enforcement institutions are demonstrating the will and the capacity to confront the tide of corruption and hold accountable those responsible. I share the view that Brazil will come out ahead in this respect and even serve as a model for other nations who need to aspire to a higher level of the rule of law, which underpins economic and political stability. Minister Dias Toffoli was named to the court by then-President Luiz Inácio Lula da Silva in his early 40s, one of the youngest ministers to serve on Brazil's highest court. He studied at Brazil's most prestigious law school at the University of São Paulo, working at night, I gather, in some various jobs to support his education. For a while, I think word has it that you might have been a cashier in a pizza palace to make ends meet, and has risen dramatically in his career following law school to the highest court. He has and will continue to have major responsibilities as a member of the highest court. From 2014 until earlier this year, he led the country's Superior Electoral Tribunal, which supervises elections at all levels in Brazil. He's scheduled to become president of the Supreme Court in September of 2018, according to the tradition of rotating the position among the justices. Before appointment, he held the position of Federal Solicitor General, and before that served as General Counsel of the Workers' Party. So today, Brazil is facing a corruption scandal on a large scale, but I think we must admire the determination of the country's independent judiciary, public prosecutors, and the federal police, as well as the Brazilian press and public in their attention and concern, and the will to forcefully address these challenges. Today, Minister Dias Toffoli will share his views about the evolving role of the Brazil Supreme Court. Please join me in welcoming Minister José Antonio Dias Toffoli.
Thank you, Wilson Center, for the opportunity to speak to so distinguished audience here today. And thank you, Anthony Harrington, by the warm welcome and the warm introduction about me. Thank you, Paulo Sotero. Thank you, our Brazilian friend. I could say that about Peter Massett. It's a Brazilian friend, very strong member of the judiciary branch here in the United States, but a so long time ago, initialized a relationship with the Brazilian branch, and it's in truth now a Brazilian for us in
Honorary
this,
Brazilian.
yes, in these relationships. It's an honor to be here with my ambassador, Luiz Alberto Figueiredo, dear friend, and other friends like Juliano Basile from my faculty, from my lawyer school. He was the president of the class associations, the famous 11 de Agosto, the gremio of our school, and the other other journalists from Brazil that are here to hear this speech, and the honor audience. I apologize that I will do a big introduction about history. And I know that is so boring sometimes, but to understand what is happening now, I think it's important to know the context of the history of Brazil in the last times. So let me. And when I was lawyer, I speak stand. But after 8 years like judge, we speak in the branch. So like judge, I will speak here in the branch, in the table. Okay. Democracy in Brazil. The involved role of the country's Supreme Court. Introduction. Though the legal system of Brazil follows the civil law tradition, in which laws issued by the legislative branch are the essential source of law, the similarities with the legal system of the United States are quite remarkable, despite the fact that the latter system is firmly rooted in the common law tradition. The similarities can be traced back to the reasons that led to the creation of the respective Supreme Courts, and above all, to the historical influences of the United States model on Brazilian law, representing a major contribution to the construction of our system of control of constitutionality. Both in the United States and in Brazil, the creation of the Supreme Court was founded upon the need for attributing the roles of guardian of the Constitution, court of the Federation, and to a kind of moderator of political and social conflicts to a single specific entity. Currently, in Brazil, Supreme Court's major role has been now that one of a criminal court, overseeing inquiries and criminal suits involving federal authorities, entitled to the named the prerogative of jurisdiction. At this point, I will go into an analysis of each one of these functions of the Brazilian Supreme Court. The first one, the Federal Supreme Court as guardian of the Constitution. It was here in the United States that the first right constitutions arose and the theory of constitutional supremacy developed. This constitution became, by the way, the paradigm of contemporary constitutionalism. Although the 1787 United States Constitution does not expressly foresee the function of jurisdictional control of the constitutionality of legislation, Alexander Hamilton, one of the authors of the Federalist Papers, defended the importance of the courts in declaring the nullity of legislative acts that conflicted with the Constitution. He argued that no legislative act contrary to the Constitution could be valid, since when the will of the legislative branch, as expressed in its laws, conflicts with the will of the people, as expressed in the Constitution. The justice would have the role of ensuring the supremacy of the fundamental law. Years later, in 1803, the same reasoning was defended by John Marshall in a decision handed down by the United States Supreme Court in the famous case Marbury versus Madison, declaring the unconstitutionality of a normative act that attributed authority to the Supreme Court to judge concrete cases not expressly foreseen in the Constitution. This came to be considered the first landmark decision involving constitutional jurisdiction and diffuse control of constitutionality, principles that later spread throughout much of the world. One should note that the American model of judicial review resulted from a construction of the United States Supreme Court based upon the notion that all judges, when judging cases, have authority to deny application of any law that conflicts with the Constitution, the named diffuse control. In its turn, since the country was colonized basically by the Portuguese, there is no denying that Brazilian law is rooted in European continental law and the civil law tradition. Therefore, in detriment to jurisprudential precedents and customs, our legal system prioritizes writing law issued by the legislative branch as the essential source of law. However, this essential difference did not prevent Brazilian constitutionalism from being influenced by the United States constitutional model, particularly with the advent of the republican system in Brazil. However, differently from American judicial review, Brazilian constitutional jurisdictions, even as a consequence of the primacy of law, did not result from a jurisprudential construction, but rather from an express provision in the Constitution. The fact of the matter is that during the monarchical period in Brazil, under the aegis of the 1824 Constitution, our first constitution is from 1824, we already have had 7 constitutions in Brazil. I will talk about it during my presentation. Under the age of the 1824 Constitution, the legislative branch was charged with drawing up legislations, interpreting it, suspending it, and even repealing it, while also acting as guardian of the constitutions. The role of judicial review is not from the judicial branch at that time, at the monarchical time, but to the legislative branch. In the name of the separation of powers and the supremacy of the parliament, there was no space for a system of judicial control of the constitutionality of laws at that time in Brazil. It was only with the proclamation of the Republic in 1889, initially with the creation of a federal Supreme Court by decree number 848 in 1890, and following that, the promulgation of the 1891 Constitution, our second constitution, but the first Republican constitutions in Brazil from 1891, which, as conceived by Brazilian lawyer and politician Rui Barbosa, a scholar of the United States legal system, was clearly inspired by the constitution of that country. The Brazil adopted so the diffuse model of control of the constitutionality of legislation, including an express provisions in this sense in the nation's constitutions. This was the start point for Brazilian constitutional jurisdictions. Nonetheless, as already stated, exclusive adoption of this model without the mechanism of stare decisis, that is an institute typical of countries adopting the common law tradition, ended up generating instability and insecurity. We create the judicial review, but without the cultural of the stare decisis that is specifically from the Anglo-Saxon common law traditions.
Being bound by precedent,
Yes.
for
Yes.
those who are not lawyers here.
Yeah. Although judges and courts with the Federal Supreme Court as the highest level of appeal could declare a specific piece of legislation unconstitutional, the effects of these decisions, were limited to that case, only to that case. Since no mechanism had been adopted that would make such decisions generally applicable. In attempt to correct this deficiency, the 1934 constitutions, or third constitutions, second in Republican time, 1934, Brazilian Constitution granted the Federal Senate authority to wholly or partially suspend execution of normative acts declared unconstitutional by the Federal Supreme Court, thus make it that declaration of unconstitutionality that was made in a specific case by the decision of the Senate could be applicable throughout the nation. This authority of the Brazilian Senate still exists even today. Control of constitutionality was maintained in these terms with no major alterations until the advent of an amendment to the 1946 Constitution, or fourth Constitution in the history, and the third in the Republican times, 1946. In 1965, an amendment to the Constitution of 1946 introduced an alteration that adopted in Brazil the abstract control of the constitutionality of laws, granting the Federal Supreme Court authority in action brought directly before the court to analyze questions of constitutionality in abstract manner without referring to a specific concrete case. Only the Prosecutor General was standing to present this suit at the Supreme Court. Only the General Prosecutor could stand this case in the Supreme Court. Thus, it was inspired by the Austrian model formulated by Hans Kelsen. The system of concentrated control of constitutionality was introduced into Brazil. Kelsen held the position that oversight of the constitutionality of legislation should be the exclusive responsibility of a constitutional court designed specifically to be guardian of the fundamental law and an institution outside the ordinary jurisdictional structure. It's not the case of the Supreme Court in Brazil, because the Supreme Court in Brazil shows the highest level of the judicial branch. This new model, denominated the concentrated control of constitutionality, coexists with the diffuse system of control, and was preserved in all Brazilian constitutions subsequent, including the current 1988 Brazilian constitutions, the seventh constitution in Brazil, and the constitution that is now applicable in Brazil. Consequently, although Brazil initially instituted a system of diffuse control of constitutionality at the time of the founding of the Republic, under the undeniable influence of the United States system of judicial review of the constitutionality of legislation, the country has gradually evolved toward the Austrian system, the European system of concentrated control. Current analysis of the 1988 Federal Constitution shows that the country does in fact have a model characterized as eclectic or mixed, a combination of diffuse or incidental control, like here, United States system, exercised by all judges and all courts, and of concentrated control centered on a single mechanism, exercised through abstract actions reserved exclusively to the Federal Supreme Court. Therefore, Brazil has combined the characteristics of the two classical models of control of constitutionality, possessing a wide range of procedural instruments through which citizens and legal and political entities can exercise oversight of the constitutionality of the acts of public authorities while guaranteeing the supremacy of the federal constitutions. With the promulgation, with the enactment of the current 1988 Constitution in Brazil, that was enacted following a military regime that lasted more than 20 years, the nation adopted an extensive range of rights and principles that, in the classic affirmation of Conrad, has possessed normative force that needed to be guaranteed by the judiciary. Here, there is no way of avoiding comparisons between the constitutions of Brazil and of the United States, though there are undeniable similarities between some instruments. While the American Constitution is synthetic, possessing only 7 articles, each one of them with several sections, the Brazilian Constitution is analytical, being structured into 250 articles. It's not problem of translation. 250 articles in the permanent part and 100 articles in the transitory provisions. One should further stress that the United States Constitution dates to the 1789 and has been amended on only 27 occasions. Brazil, on the other hand, has already had 7 constitutions, and that currently in effect dated 1988, just 27 years of existence, has already received 91 amendments. 91 amendments in 27 years. The truth is that our constitutional test, to some extent as a result of the recent military regime period, sought to exhaustively define all constitutional questions. The Constitutional Congress put everything in the test. All constitutional questions, while also disciplining various questions that could have been defined by infra-constitutional legislation. Most part of our constitutions could be put in the infra-legal bills, but at that time, everybody, every press group needed to put everything in the constitutions because they thought it will be the only way to guarantee the rights in our system. This wide-ranging proclamation of rights by the Constitution was further accompanied by creation of instruments designed to bring these positive intentions to judicial fruition, granting to the judiciary, and more specifically to the Federal Supreme Court, a fundamental role in the consolidation of the fledgling democratic state and in safeguarding the fundamental rights and guarantees of both individuals and society as a whole. If you put in the Constitution, you need to guarantee these rights. And who will guarantee these rights? The judiciary branch. Concentrated control through which constitutional controversy can be directly analyzed in abstract terms by the Federal Supreme Court and can be exerted through 4 types of constitutional challenges. The abstract control. We have 4 challenges that could put directly to the Supreme Court. One of them, the first one, direct challenging of unconstitutionality. The second one, declaratory action of constitutionality. It's interesting. We have the direct act of unconstitutionality and the direct act of constitutionality too. Third, direct challenger of unconstitutionality by omission, when the legislative branch don't and issued the bill that regulate the rights guaranteed by the Constitution, but that needs an infralegal bill to regulate. And fourth, challenging of breach of fundamental precept. This is inspired in the German Constitution. Parallel to this, the 1988 Constitution significantly broadened standing to raise challenges, granting this legitimacy to the office of the General Prosecutor of the Republic. Since 1965, only the General Prosecutor could switch this abstract control. But after the 1988 Constitution, this standing was extended. Beside the General Prosecutor, look for the President of the Republic, the leaders of the Federal Senate, the leaders of the Chamber of Deputies, the leaders of legislative assemblies or the legislative chamber of the Federal District, governors of the states and Federal District, the Federal Council of the Brazilian Bar Association, to the political parties with representation in the National Congress, labor confederations, and professional entities that are national in scope. So, a big stand to present at the Supreme Court this kind of challenges. Also, in the context of constitutional challenges, we have the writ of mandamus, habeas corpus, habeas data, injunctions, class actions, and the public civil actions. At the level of appeal, one should cite the extraordinary appeal, in which the Federal Supreme Court is called upon to analyze the existence of violations of the Constitution in judicial decisions handed down by a single or final instance of other judiciary branch components. This is the paper of highest court in our system that the Supreme Court, Federal Supreme Court in Brazil do. In this point also, on encounters converging elements in more recent times between the Brazilian and the United States models of judicial control of constitutionality. The enormous quantity of cases brought before the Federal Supreme Court in Brazil, mailing with the extraordinary appeals, had made it necessary to adopt mechanisms capable of filtering the cases to be heard by the court and granting the status of precedents to those applicable to analogous cases. Exemplifying the numerical crisis, 20,000 cases were brought before the Brazilian Supreme Court in 1988. 20,000 cases. In 26, it was a total of 127,000 cases. 127,000 cases in 26. In this framework, the 24 judicial reform, and particularly a constitutional amendment number 45, introduced the profound alteration into the extraordinary appeal, a procedure instrument typical of diffuse control of constitutionality. undubbed, it was based on the concept of the counterpart of certiorari, the concept of general repercussion, what you in the United States would call discretionary review, was adopted as a requirement for admission of extraordinary appeals by the Brazilian Supreme Court. By way of clarification, the appellant must demonstrate the general repercussion of the constitutional questions discussed in the case in order to have their appeal heard by the Supreme Court. In other words, appeals must be relevant from the economic, political, social, or legal points of view and must extend beyond the subjective interests manifested in the single case. Thus, the court only agrees to decide constitutional controversies that it considers to be relevant. With this, upon deciding a specific extraordinary appeal with acknowledged general repercussion, the Federal Supreme Court not only judges the concrete case, the single case before it, but also defines the interpretative reasoning behind the constitutional question and under discussion, which must then be followed by the lower courts in cases dealing with the same theme. And its enforcement. It is with enforcement. They need to apply the Supreme Court decisions, in this case with general repercussion. Following the same inspiration, another innovation introduced by Constitutional Amendment number 45, dated of 24, was authorization for the Federal Supreme Court to approve so-called binding precedents, by which reiterate decisions of the Supreme Court are defined as precedents applicable to the other levels of the judicial branch and the direct or indirect public administration at the federal, state, and municipal levels. This is important note here, observe here, that this blinding precedents is enforced to the administrative branch too, to the executive branch too. And not only for the courts, local courts, or local judges. It's enforcement to the administrative branch too. And if an administrative governor don't apply the decision, the particular could go directly to the Supreme Court with a claim direct to the Supreme Court. One should observe that at the end of 2006, the number of cases before the Federal Supreme Court totaled 153,000 cases. Currently, 10 years after since the regulation and implementation of the system of general repercussion and binding precedents, the court has sharply reduced the backlog to a current level of 62,000. 62,000. It's so many cases yet. The truth of the matter is that both mechanisms, general repercussion and binding precedents, have converged to form the current mixed Brazilian system of judicial review, diffuse and concentrate, make it possible to give added value to the jurisprudence of the Federal Supreme Court. While ensuring jurisprudential uniformity and enhancing the strength and generalist character of specific precedents defined by the nation's highest court. In summary, in attributing the role of protagonist to the Federal Supreme Court in interpreting and solidifying constitutional norms in 1988 Constitution has conferred a more active character on the court in the sense that its decisions have clearly highlighted the institution's overriding commitment to the defense of fundamental rights as well as its untiring efforts to combat discrimination and intolerance, certainly elements of fundamental importance to any and all democratic societies. Further on, I will cite several decisions that clearly demonstrate this role of the court. Second important role of the Supreme Court, the Federal Supreme Court as a court of the Federation. Hans Kelsen defended the position that it was precisely in the federal states that constitutional jurisdiction took on the greatest importance, since it was at the level that a constitutional court was needed, an objective instance capable of peacefully deciding conflicts among federative entities as problems of a legal nature. Therefore, aside from being a response to the need for ensuring the supremacy of the respective fundamental laws, the Brazilian and United States Supreme Courts also represent a response to the need for a national jurisdictional organ charged with impending violations of the constitutional limits imposed on the authority of the federative states. It is the understanding of Charles Duran that true federalism demands that the Constitution must rule both the member states and components of the federal government. This requires the existence of a neutral court that resolve conflicts between the federations and the member states, particularly with respect to the authority constitutionally distributed to the states. Just as occurs in Brazil, the United States Court has original jurisdiction in conflicts between member states or between them and the federal government. Article 102(1)(f) of the Brazilian Constitution determines that as Court of the Federation, the Supreme Court has the power to resolve those controversies that arise at the core of the federal state, generating situations in which conflicts arise among the member states. The Brazilian Supreme Court has the political institutional duty to defend the intangibility of the Federative Pact. Some part of this case is a tax war that the states are doing in Brazil at that time. By way, for exemplification, in 2011, the Federal Supreme Court denied the petition formulated in a direct challenger of inconstitutionality, for which I was the reporter, declaring that in hypotheses involving the breaking up of states and municipalities, the entire populations directly impacted, including that one of the area to be dismembered, and that of the remaining area must be heard through a plebiscite. As foreseen in Article 18, the Federal Constitution, the decision in this case generates important repercussion on those movements calling for territorial alteration in the Brazilian Federation, making the breaking up of the respective states considerably more difficult. It had a direct impact on the first movement toward emancipation of member states after adoption of the federal constitutions of the state of Pará and creation of the states of Tapajós and Carajás both of which were rejected in the 2011 plebiscite. So we decided that the entire population of the state need to vote in the plebiscite, and not only that part of the state that wish to separate. This was a decision considered historic in the sense that it involved defense of the idea of the federation and of the limits on federative self-determination. If you will observe the cases of Crimea, Catalonia, or Scotland, it in its own specific context, we will have a precise notion as to what this decision represents in terms of the future of the country and its view of the concept of federalism and union. In the position I take in the Brazilian Supreme Court, I often stress that the history of Brazil, in the past as colony, empire, or now republic, demonstrates that many of the debates that reached the Supreme Court are the result of the permanent pendular movement of the Brazilian Federation. What is this pendular movement? It is that existing between granting greater authority to the local elite or to the national state, between attributing enhancing legitimacy or authority to the member states or to the federation, to the union, to the central power, between fostering decentralization in favor of the states or centralizations in the benefit of the union. As it's evident, the Brazilian Supreme Court acts as a type of arbiter of the federation, resolving constitution-based conflicts that may arise. On occasions, with the endorsement of the Supreme Court, the states enjoy enhanced constitutional freedom, while on other occasions, this freedom is restricted in favor of the federation. There is no doubt that these interpretations oscillate between broadening federal authority and defending states' rights, depending on historical moments and the process. Brazil is a big country with 26 states and 1 district federal, 5 regions, and a difference of distribution of riches in the whole country. The Supreme Court, now I will talk about the role of the Supreme Court as a moderating power. Today, the Federal Supreme Court plays a highly relevant role in maintaining constitutional balance, intervening in moments of tension between the executive branch and the legislature, and avoiding situational political conflicts capable of leading to rupture of the constitutional system. In Brazil, the Federal Supreme Court acts as a moderating power in political and social conflicts. And why not talk about the cultural conflicts too? Looking back once again to the history of Brazil during the imperial period, it was the broad authority of the moderate power, the emperor, our first constitutional in the monarchical times, had a moderate power, just like Benjamin Constant wrote in that 19th century. In the beginnings of the 19th centuries, the need in a democracy to have a moderate power. And in 1824 Constitution of Brazil, this moderate power was exercised by the emperor. Looking back once again to the history of Brazil during the imperial period, it was the broad authority of the moderating power, the emperor, that preserved national unity, the borders of the Brazilian nations and made it possible to expand them. The end of the monarchy and the proclamation of the Republic as a result of an army-led coup in alliance with the upper and lower national middle class resulted in a new constitutional model for Brazil. In the absence of the figure of the emperor, the final instance for resolution of public and private conflicts had to be defined, since that function had previously been performed by the emperor himself. Following the model of the United States Supreme Court, it was this need that gave rise to the Federal Supreme Court, which assumed many of the responsibilities previously attributed to the emperor, moderate power, and to the Council of State. However, it was a new institution. However, the Supreme Court of Brazil at that time was a new institution, but with old ministers, since many of those nominated to the court had been born in the decade of independence days, 1822. The truth is that even with the renovations that occurred at a later date, the court was unable to achieve the desiderata that had undergirded its creation. Parallel to this, the military, responsible for the Republican coup, disdained the Supreme Court, as occurred, for example, in the episode in which Floriano Peixoto named a medical doctor, Barata Ribeiro, and 2 generals to the court. When these names were rejected by the Senate, the court was forced to spend a long period of time without the quorum required for its deliberations. In its turn, the army played a role in all of the crises that marked the birth of the Republic, including both in wars and in support to national unity. However, only rarely did this reality impact the Supreme Court, as it avoided coping with the military and political dispute of the period. With the failure of the proposal of the court at that time as moderate power, the political culture of the nation sought to obtain authority by resorting to the armed force and its officers. Consequently, during the entire period of the Republic, up to the 1988 Constitution, the role of moderating power, in fact, in Brazil, was exercised by the military, which took on the joint roles of guarantor and mediator of crisis, constantly interfering in the power structures and directly and periodically intervening in Brazilian democracy itself. However, this approach consisted of a veritable usurpation of the role reserved to the judicial branch as principal actor and mediator of conflicts, especially at the level of the Supreme Court, as occurs in the United States. There is no doubt that in the United States, the Supreme Court effectively plays the role of horizontal and vertical moderate power, mediating the major themes faced by that society, whether they involve political, economic, social, or cultural life. Examples of these are evident in decisions related to abortion, Roe versus Wade, and to elections, Bush versus Al Gore, among others. We could sit a little. Okay. At this moment, the Federal Supreme Court seems to have begun assuming the role originally foreseen at the time of the proclamation of the Republic. As expected, complaints have been raised regarding supposed judicial activism and interference in the other branches of government, in terms that should be the responsibility of the elected representatives of the people. In this regard, one should recall recent moments of the so-called judicial activism in Brazil with a brief, albeit summarized glance at important decisions handed down by the court in recent years. For example, I will only cite the case. I will not read because of the time, but the center will publish the address. By example, in May 2011, the Supreme Court recognized civil unions for couples of the same sex, recognizing that they have the same rights as heterosexual couples. Another relevant theme that has been the subject of decisions in both the United States and Brazil is that of racial quotas in universities. In Brazil, in 2012, the Federal Supreme Court decided that this affirmative action policy was constitutional and consistent with utilization of social and ethnic racial criteria in the process of admission to Brazilian public university. In the political framework of our country, the reality of a coalition-based presidential system coupled with the fragmentation and composition of the political force represented in Congress. For example, the big party in the House has only 10% of the congressmen. The bigger part has only 10% of the seats. And we have 26 parts in the parliament. We use the proportional system, so it permits that the parliament can be accessed by several parts. And because that fragmentation and composition of the political forces representing Congress, together with the fragilities of our political party structure, also requires an institutionalized and legitimate space for mediation of conflicts in moment of political crisis. In this sense, the Brazil Supreme Court has also taken a number of pertinent decisions. All the parties that lose in the parliament goes to the Supreme Court because they stand of the challenge of directly inconstitutionality of the laws. In Brazil, just as occurs in the United States, the theme of political financing has also been targeted by the Supreme Court. And an important decision in 2015, just a year ago, the Brazilian Supreme Court declared the unconstitutionality of the rules that allowed private companies to donate funding to electoral campaigns and political parties. This represents an enormous innovation that will go into effect in the 2006 October municipal elections. And it's also important to cite the ongoing process of impeachment of the President of the Republic and the fact that Supreme Court has been called upon to define the ritual to be observed by the National Congress in this case. The court also denied injunctive relief that would have annulled processing of the impeachment in the Chamber of Deputies. One should also emphasize that just as occurs in the United States, Brazilian Federal Constitution designates the Chief Justice of the Federal Supreme Court to preside over the process of impeachment of the President of the Republic. The proceedings are now moving forward at the Federal Senate. These decisions are a clear example of the measures taken by the Federal Supreme Court in its role as moderate power, acting in situations of tension between the executive and legislative branch, and a mediator in moments of institutional crisis. At last, but not least, Federal Supreme Court as a criminal court. Different from the United States, we have this role. Finally, is it important to highlight the outstanding role played by the Federal Supreme Court in Brazil, distinguishing it even from its source of inspiration, the Supreme Court of the United States. Original criminal jurisdictions and the so-called prerogative of functions for those entitled to it. In this case, the court functions as a criminal court, starting with the investigation, gathering of evidence, and trial of those involved, and continuing during the stage of appeal. In the United States, the concept of privileged jurisdiction by reason of prerogative of function does not exist for common crimes, since only the President of the Republic has temporary criminal immunity until leaving office. In contrast, countries like France, Germany, and Italy have rules that protect their highest authorities, granting them the right to be tried before higher courts. In Brazil, there has been some form of special jurisdiction since the 1824 Constitution, the first in Brazilian constitutions. Currently, Article 102(1)(b) and C of the 1988 Constitution determines that in cases of common crime, the Federal Supreme Court has original jurisdictions for trying and judging the President of the Republic, the Vice President, members of the National Congress, government ministers, and the General Prosecutor of the Republic, and when common crimes and the abuse of office are involved, ministers of state and the commanders of the Navy, Army, and Air Force, members of the higher courts, member of the Federal Budget Court, and the chiefs of permanent diplomatic missions. Although its existence is now the subject of heated controversy, I remain favorable to the rules governing privileged jurisdictions, since it's my understanding that in a federation, the only who judges the maximum authorities of the Brazilian nation should not be the local authority, in this case the lower court trial judge, but rather an entity of the Brazilian nation. The Constitution has chosen the Federal Supreme Court, the maximum level of the judiciary branch, to perform this task. It is important to stress that privileged jurisdiction is not designed to benefit those who exercise the position listed by rather to guarantee the independence of the performance of their functions, while also avoid political manipulation in the judgment process and subversion of a hierarchical structure. This is not a question of privilege, quite to the contrary. Those who have this prerogative are also subject to a lesser number of levels of appeal and lesser chance of future application of the statute of limitations, since the process of judgment is more rapid, considering that the case is tried only by the Supreme Court. Execution of sentences is immediate without possibility of appeal. The fallacious idea that this prerogative is a privilege and that those entitled to it benefit from these jurisdictions as a result of impunity result from delays is in fact a consequence of in the past, existence of formal immunity in the past for deputies and senators since the first Constitution, 1824, until an amendment to the 1988 Constitutions, an amendment number 35, that was enacted in 2001. So, since 1824 until 2001, the members of the Congress had a immunity. To suit a congressman, the judiciary branch needs approval by the majority of each House of Representatives or the Senate. It changed in 2001. So, since then, the judiciary branch, the prosecutor and the federal police can investigate the congressman. This immunity determined that deputies and senators could not be criminally tried without the permission of the respective House of Congress. And that amendment changed it. With this constitutional reform, investigations have moved forward on a regular basis and criminal activities have been judged, resulting in convictions of several members of Congress. One should add that since 1988, some numbers, 628 criminal suits were processed at the court, with 622 of them being initiated after passage of Constitutional Amendment number 35 of 2001. An emblematic case of the role of the Brazil Supreme Court as a criminal court and the figure of jurisdiction based on prerogative function was the criminal action number 470, known popularly in Brazil as the mensalão, which, among other things, involved the practice of financial crimes and crimes against the public administration by business persons, members of Congress, and the Brazilian government authorities. After accepting the charge against 40 suspects of involvement in these crimes, criminal action number was processed over a period of 5 years, during which it was prepared for judgment by the full court. Of the 40 persons initially charged, these 37 of them include Brazilian business persons and politicians were tried by the Federal Supreme Court. It should be emphasized that not all of the defendants were entitled to privileged forum due to the prerogative of functions. Despite this fact, the case remained under the jurisdiction of the Federal Supreme Court, which processed and tried all of the defendants. This situation was a result of illegal functions foreseen in Brazilian process law and known as connection, which, according to Article 76 of the Criminal Process Code, exists in most cases when two or more crimes have been committed at the same time by various people together. Parallel to this, an effort is made to avoid possible prejudgment without overall understanding of the facts and the pursuit of the real truth of the case, a trial of defendants who had participated in a highly complex system of money laundering and concealment of health. In this specific case, by acting in this way, the Federal Supreme Court ensured equal treatment to all of the accused, while also avoiding contradictory decisions that could potentially have occurred if the case had been dismembered and part of the process remitted to lower-level courts considered competent to judge those not entitled to the jurisdiction of the Supreme Court. Some numbers about this case. The process itself contained approximately 50,389 pages distributed into 234 volumes and 500 appendices, and was initiated on August 2, 2012, and concludes on December 17, 2012, with the hand-down of the sentence imposed on the accused. In other words, in just over 4 months, the court dedicated 53 plenary sessions to the case, involving a total of 203 hours and 40 minutes of debates before finalizing the trial of the 37 persons charged, who were represented by 36 lawyers, resulting in 25 convictions and 12 acquittals of the crimes indicated by the Office of the Federal Prosecutor in the original charges. The sum total of the punishment meted out by the Federal Supreme Court ministers to the 25 convicted persons surpassed 200 years of incarceration. I'm going to the end. From the point of view of the judgment of these criminal actions, the Federal Supreme Court amended its internal bylaws and shifted authority to judge that case from the full court, composed of the 11 members, to what are termed the first panel and second panel. Each one is composed of 5 ministers. Nowadays, because of that big case, we divided the decisions in 2 panels to become more rapidly to decide, because the full panel we have 11, and in each panel we have only 5 ministers. By proceeding in this fashion, the court has sharply reduced the waiting time for trying these criminal actions. In this sense, the case resulted from the so-called car wash operations, nowadays a big operation in Brazil, investigation in Brazil, now before the court, are moving forward with considerable efficiency. Charges against members of the Congress, including 2 against the Speaker of the Chamber of the Deputy, whose congressional mandate was recently suspended by the Supreme Court as a result of attempts to tamper with investigations, have already been accepted by the court, while a senator was arrested in the act of committing a crime in the last December, by a decision of the Supreme Court. This example of improvements in the processing and judgment of criminal actions have resulted in the enhanced expertise required by the Supreme Court for greater celerity and uniformity in the performance of functions, while serving as a parameter for other judges and courts belonging to the Brazilian judicial branch. Therefore, the Federal Supreme Court has demonstrated that it is prepared, adapted, and competent to perform the function of criminal court in rapidly judging those criminal actions now before the court, involving the highest authorities of the Brazilian nations in an independent and impartial manner. A title close. I would present my conclusions synthesizing in one word the mission of the Supreme Court nowadays: challenger. Challenger. After all this, and I skip some parts of the address to not be so boring, but it will be published. We are in a big challenge in Brazil nowadays. The Brazilian Constitution embodies as an extensive list of rights and guarantees, and also establishes the jurisdiction of our Supreme Court, bringing the judiciary enormous challenges. Therefore, I would emphasize the following points. A, fostering fundamental rights of the individuals, not only on a vertical but also on horizontal criteria. B, mediate conflicts of federative nature, such as tax wars between states of the federation, and even if such issues are effectively do it. C, trying criminal cases against specific politicians, such as ministers, congressmen, senators, as defined by the Constitution. D, balancing the separation of power as the moderator power in order to enhance the harmony and effectiveness of the Republic. E, by political and legal circumstances, currently try to process of impeachment of the President of the Republic, observing the due process of law. And a particularity, the fact is that there are challenges, and the Supreme Court has sought to overcome them with fairness, efficiency, and transparency. Regarding transparency, all of our judgments are allowed to the public and simultaneously broadcasted through internet, radio, and TV, alive. It is clear that the mission to judge with fairness over 11,000 cases per year in the full panel, only in the full panel, many of them of interest to the whole nations, cannot be ignored. All this is for effort to comply with its challenges has placed the Supreme Court, and with the broadcast by TV, to the center of the country's attentions. This is so true that today Brazilian citizens cannot remember all the names of the 11 players of the Brazilian soccer team, but they certainly know the name of each of the 11 justices of the Supreme Court. I would like to apologize for the long expositions. I expect that it was not so boring, and again say my thank you to the Wilson Center, to Paulo Sotero, the Brazilian Center Institute here, and my colleagues in Brent.
Thank you very much. I would like to invite Judge Massetti to say a few words.
All right,
or
thank you.
comment.
Thank you, Paulo. And Minister Toffoli, Ambassador Figueiredo, Ambassador Harrington, Mr. Sotero, my old pal, and Wilson Center, thank you for having me today. Thank you for your kind words, Ambassador Harrington. I take them all with great pride and joy. Some of you old-timers will remember a comedian named Father Guido Sarducci, who used to stand up and give a history of the world in a minute. I'm going to take a little bit longer with a little less humor, but I do want to say a few things that have some historical relevance and some geographic relevance, because I think they play into what you've heard this morning from Minister Toffoli. Let's start by, for example, comparing these two countries in size. I mean, we are roughly geographically the same size, a little bit bigger in the United States. We have 320 million people. Brazil has somewhere over 200 million people. We have 50 states in a federal district. They have 26 states and a federal district. That's where we are. So that's sort of where we are in the dimension. Brazil, of course, is overwhelmingly important in Latin America. More people, more land than all the other countries put together. So that's for starters. So let's look a little bit at some of these other issues. And historically as well, and I say this in part for Americans who are not familiar with Brazilian history, even for Brazilians who are, this might be helpful to hear. You've heard Minister Toffoli talk about various periods of history. The colonial period, which runs roughly from 1500 to 1800, and then the imperial period, which runs from roughly 1800, a little more into the century, to the end of the 19th century, and then in 1889 you begin the Republic. Now, after the Republic, you had a somewhat democratic situation. You did have a military dictatorship intervening with Getúlio Vargas. You had a military dictatorship intervening. These are all relevant, in my view, to some of the things that you find in the legal system today, including at the constitutional level. For example, when you go back to the imperial period, this was, again, for those of you who are not familiar, the Portuguese king came from Portugal to Brazil, stayed there. His son was there. His grandson was there. It wasn't a bloody revolution. He said, I'm staying, fico. And that was the way Brazil declared its independence. Now, you heard the minister talk about moderating power. The emperor was the moderating power, not moderate in the sense of being modest. He was the last word. It wasn't the courts who decided the disputes. The moderator was the emperor. And eventually, over time, today, we see that the moderator today is the Supreme Federal Tribunal. But that is the course of history. When the military was in charge in the 60s and 70s, they were the moderating power, the moderators. And so that's something that you have to see, because look, a colony for 300 years, there weren't 13 separate colonies, independent, like the United States. We have issues of states' rights and state sovereignty here that you don't really find in Brazil, because they were one big colony, and we had 13 originally, so you see that. Likewise, we didn't have a king here. We didn't have an emperor here. We never had a military dictatorship in control. All these things are quite relevant to bear in mind, because it bears on, in my view, what the minister has said about this very large Constitution of 1988, which puts all these fundamental rights and guarantees out there the way our Constitution does not, because he says, in effect, we got to do it there because we can't be sure it's going to happen unless we do. So that's an important thing to bear in mind given the history of Brazil. Now, I want to say a little bit about the structure as well of the legal system because, again, that too is important. Brazil is largely of the civil law tradition, the Romano-Germanic tradition actually is better said. We in the United States of the common law tradition, but in constitutional matters, Brazil really does, as the minister pointed out, track a lot of institutions of the United States constitutional history. There are some aspects of European and other systems that I'll talk about momentarily, but essentially that is where we are. Brazil has got a tripartite government, executive, legislative, judicial. It is a federal system in the sense that there is a federal government and there are state governments, but nothing like the tension between the federal government and the states that you find in the United States. We're talking about state sovereignty. We're talking about states' rights here. That isn't a battle that gets fought frequently in Brazil. The law, as most of you know, even though it's applied by both federal and state courts, is essentially national in scope. The National Code of Criminal Procedure, a National Code of Civil Law, Civil Procedure, Criminal Procedure, that isn't our system. We have one set of laws for the federal government and 50, theoretically, plus one federal district systems for the states. And there's tension. They don't have that same kind of tension that we do.
Electoral law is.
What's that?
Electoral law is national.
The
Electoral
law is national.
Yeah, and electoral law is national. I mean, all this is national in Brazil, not so here. We have federal electoral law as well. But that's an important thing to bear in mind because the structure of the government and the judiciary in particular is somewhat different in terms of the relations. It's true, they have courts of first instance, which we call trial courts. On the federal level, they have intermediate appeals courts, federal appeals courts. And they have, and this is something very important to understand, before you get to the Supreme Federal Tribunal, there's something called the Superior Tribunal of Justice. The Supreme Federal Tribunal on which the minister sits is essentially a constitutional court. For all what they call infra-constitutional issues, the Superior Tribunal of Justice is the final word. So they separate that. We don't have that. We have in the federal system 12 regional, geographic federal regional courts. We don't have a super court of appeals in the United States. Again, important difference. So that I want to bear that in mind. The court structure as well. They have courts that we don't have here. Labor courts. We don't have labor courts in this country. They have a very extensive system of military courts. Ours is much more modest by comparison. They have a tribunal of accounts, which monitors government spending, which is frankly behind what is, I think, the impeachment proceeding against Dilma Rousseff. Now, we don't have a tribunal of accounts in this country. So there are a lot more court systems, and many of these court structures derive from European models. So it's important to keep that in mind, that Brazil and the United States are alike in many ways, but there are these differences that come in structure. Now, let me talk a little bit about the composition of our Supreme Court and compare it with the composition of the Supreme Federal Tribunal, and also some of the practices which you'll see both similarities and differences. 11 ministers, we call them ministers, they're not really cabinet members, but that happens to be the word that they use for justices in Brazil. And we have nine justices of the Supreme Court, 11 versus 9. That's one difference. In Brazil, in the Constitution, it says who can be on the court. Got to be between 35, not older than 65. You got to have a sterling reputation, right? All these things that are there. In the United States, what does the Constitution say about qualification for the Supreme Court? Nothing. There's nothing written in there. And you don't have to be a lawyer, according to the Constitution. Now, by tradition, we hope most of the members have been lawyers, but there's that difference, too, that Brazil has been very specific about who can be on the court. And, of course, notable learning in the law is an important qualification in Brazil. That's all written in the Constitution. And you have to get off when you're 75. Don't have to do that here. You could stay until you die. They tell a story about Oliver Wendell Holmes in his 90s taking a train to New York. He was looking for his ticket. And the conductor came up and he said, "Mr. Justice, no problem. I know who you are." He says, "I'm trying to find out where I'm going." He was in his 90s, and at the time it was important. I mean, you can stay for a long time. As a matter of fact, somewhat amusingly, they just changed in the last few years the age of retirement for justices. It used to be 70. Now it's 75. The proposed amendment of the Constitution was called the Proposed Amendment of the Cane. Bengala. Yeah, the old guys who could walk around with their canes. Again, a kind of a good reflection of Brazilian humor. There is not only that procedure, but there is a kind of the Chief Justice doesn't stay forever in Brazil either. Here, you'd be Chief Justice, John Marshall, 23 years, wherever. Brazil, it rotates every 2 years. And it will go in 2018 to Minister Toffoli. But again, the president nominates, the Senate advises and consents in Brazil. I would say this with all deference, although the issue in Brazil about nominating a minister of the Supreme Federal Tribunal is important, and there is very significant public attention there. Let's talk about nominating a Supreme Court justice in the United States. I mean, this is a major event. It is the major issue of the election here now. We have 8 justices on the court. That's not, that's a tie. And that's what happens in these cases. You get those kind of results. So the election, the selection of a Supreme Court justice in the United States is a huge, and it's become increasingly, I don't want to use that word huge because Trump uses it a lot, but a very important, a very, very important social fact in the United States. And that's another difference, I would say. It's a big deal. We'll see what happens with Merrick Garland. There's been reference to diffuse versus concentrated decision-making in the constitutional level. And some of you may not know what that is, although the minister knows about it well. And I appreciate his remarks. I thought he had very fine remarks about it. But I'm a judge, and I know exactly what he's talking about for the Americans in particular, and some of you others who are not particularly well-schooled in constitutional law. Diffuse constitutional decision-making means that any judge, traffic court judge, can declare a law unconstitutional. A lower court judge can do it. Now, the final word is always on the U.S. Constitution with the Supreme Court. But and Brazil, by the way, does also have a diffuse system in that regard. Some countries, only a high constitutional court can declare on what the constitutional law is. In Brazil, however, finally, the word is with the Supreme Federal Tribunal. That is, and here's another difference. In Brazil, on constitutional issues, the final word is with the Supreme Federal Tribunal. And that is true in the United States. But in the United States, on simple federal law that's not constitutional, it's also the U.S. Supreme Court that decides. In Brazil, it's the Superior Tribunal of Justice that has the final word on non-federal law, right? The infra-constitutional law. So there's that difference as well about the scope of the way our court operates. Quickly, let me go beyond where we are. Important to talk about review in the United States of constitutional issues and review in Brazil. Brazil has now adopted the idea that they will not, the highest court, review cases, the tens of thousands of cases that come in, unless they have a national impact. The word is repercussão geral, a general repercussion, which is essentially the standard in the United States too, that our court will decide cases only on a discretionary basis. There's no obligatory right of appeal to the U.S. Supreme Court, and so they exercise that same kind of discretion in deciding whether they will take cases. And this dialogue about general repercussion is one that I've been involved with for many years with Brazil, and the ambassador referred to that, and that's what one sees here. So that's an important thing to bear in mind, that we come to the same result by slightly different approach. Now here's the big difference. Brazil's Supreme Federal Tribunal gives advisory opinions. They will give, depending on who the applicant is, and it has to be the president or it has to be the head of the Senate or the head of the House of Cameras, they can come to this court and say, we would like you, here's a law, nobody's been affected by it yet, could you tell us whether it's constitutional? Could you tell us whether it's unconstitutional? You can't do that in the U.S. Supreme Court. You cannot get an advisory opinion. The Supreme Court says, the Constitution says, we only deal with cases and controversies. And unless we have an active, a raw and buzzing controversy that presents the issue. We don't decide it. The case has to be ripe. The case can't be moot. We don't issue these decisions. In Brazil, they can do this. So you have those actions that the minister spoke about. Now, is it right or wrong? It's interesting. In other words, before waiting to see whether a statute 3, 4, 5 years is constitutional, you get a read from the court right in the beginning. It's constitutional. Go ahead with it. So there's a debate. It's not going to happen in this country, but there's a debate. And of course, that is a European import. It's not unique to Brazil, but it's nothing you find in the United States. Let me see. With regard to the decisions that are made by the court as well, we talk about precedent. Because historically, as the minister said, the decisions of a high court did not bind everybody. But over time, they have developed a concept of precedent that when a high court, particularly this court, the Supreme Federal Tribunal decides, other courts are obliged to follow, but only in these circumstances. 8 of the 11 ministers have to vote that it will be binding. In our system, whatever those folks say, that's the binding law, I guess. What does it mean? Who knows? Depends on the next generation of lawyers to decide what was the holding there. How far does it reach? In Brazil, it's a much more explicit kind of a finding. In fact, you do, I think, have to announce in advance that there will be a determination and invite the participation of the executive to give their view before you announce a precedent in that regard. And there's something called deciding that certain cases are repetitive. And because they are repetitive, courts, not even just the Supreme Federal Tribunal, but other lower courts, can say, we've been deciding this case so much, we're taking a paradigm case now, everybody else stop, we're going to make this decision, and that will bind everybody. And that's a very accelerated way to deal with the law. And I might say, just having been involved with Brazil for many years, Brazil is really pretty good in the way they've attacked their judicial problems and trying to judicially reform. Give me a couple more minutes, Paulo, and I'll wind up. Decision making. In the Supreme Federal Tribunal, there is oral argument, there are briefs, but big difference. They do it openly. The justices sit there and they listen to the argument and they debate with one another right there in the open. Not true in the United States. They'll take oral argument and then the justices closet themselves away. Not even a law clerk can come in. And they discuss their cases. And then they announce the decision. And you don't even know who's going to write the decision. In Brazil, they already have somebody indicated called a relator, a reporter, and that person will be the one that writes the opinion unless he happens to be in the minority vote. So those are another, similarities, differences that you see. The Brazilian cases as well, when I say that the debate is open, it goes beyond letting the public sit in. It's on TV. There's TV Justiça, that they have where they televise what's going on so that when Minister Mendes gets into a fight with Minister Barbosa, you're there. You were there. You saw it. It was pretty tough. I remember. You don't see that in the United States. The justices don't debate on the tape. I did hear a story once, and Justice Rehnquist told me that one group was very interested in determining how the judges were thinking in a case, so they engaged a lip reader to try and watch the conversations back and forth between the justices. And apparently, Justice Douglas, I guess it was, leaned over to Justice Black and whispered something. And the lip reader said, well, here's what he said. He said, I wish Felix Frankfurter would just shut up. The other justice, that was the word. No, that's because everything is so clandestine there. Anyway, wrapping up, which I know you want me to do. Probably shorter and fewer dissents. Not too many dissents in Brazil. The opinions tend to be a little bit shorter. We have, 80 decisions a year from our court, and we get hundreds from the Supreme Federal Tribunal. Let me compare, finally, some of the cases that Minister Toffoli cited and show you how his court went one way and our court went the other way. Same-sex marriages, okay, pretty much on the same boat with Brazil and the United States. Affirmative action for minorities in universities. Well, we just had a decision a few weeks ago from our Supreme Court saying, as long as Texas we'll uniformly bring the top 10% of all graduates in, we'll get some diversity, and then race can be one of several factors. That's not what the Supreme Federal Tribunal said. They said, no, we can have a factor for race. Let's have this percentage of people of a certain race to be in our university. That they went a little farther than that. They said on campaign financing, now there's a big one. Everybody knows about Citizens United. Corporations are people, right? They can unlimited spending. Not so in Brazil. The Supreme Federal Tribunal said any attempt to limit, to prohibit limitations is unconstitutional. You can limit political campaign contributions in Brazil. And in the United States, not quite the same. They've come to a different view. In fact, there even was a decision in the Supreme Federal Tribunal not long ago that said, if you switch parties, political parties, once you're elected, there may be some option for the party that you left to have yet another option to fulfill the seat that you said you were sitting with. In the United States, there's no restriction on party switching. Happens all the time, all the time. And that's a cause for concern. So we're dealing with similar kinds of issues. Political corruption cases, of course. The public ministry and the judiciary is doing a good job there. The United States has had its own share of political corruption, whether you're talking about the Teapot Dome scandal or Abscam or anything like that. We deal with that same sort of thing. Finally, there was a lot of time devoted by the minister to what was called, he called it prerogative of forum. I think you could call it privilege of forum. Certain people at a high level in Brazil, in government, are entitled to have their cases heard, tried in the Supreme Federal Tribunal. Our Supreme Court doesn't have any criminal jurisdiction at all. Maybe if an ambassador shot somebody, they could try that because they do have a right to. Ambassador, I hope you'll not be before the court, but you could be, theoretically, but nobody else. Common crimes are not, common crimes come to a judge like me, and then they go up to the Supreme Court eventually. Not so with Brazil. When you're talking about certain crimes of high officials in Brazil, it goes to the Supreme Court to start. And that's what you've got largely the issue in the Lava Jato car wash case right now. That a number of the people who are implicated in this big corruption case are people who have this privileged forum. And so the whole case is bumped up to the court now. I think you still have the case of Lula, and you still have some of the attendant defendants there too. That court is dealing with that issue, not so in our system. Well, I've said a lot, and my time is up. I do want to say this, though, and Minister Toffoli heard me say this before. The ambassador has heard me say this before. Brazil's judiciary looks pretty good. It really does. And Brazil's public ministry looks pretty good, despite the travail that is going on in this country, and we all wish Brazil well. The leadership that's been taken, the independence that's been shown by the judiciary of Brazil really merits commendation. And I agree with the statement that was made that, and I think, Paulo, you made it, if not the ambassador, that Brazil is going to show itself to be a model in time of how to handle these inevitable political corruption problems that come up the way they've done it now. It is not a coup d'etat that's going on there. Everything that's being done today is according to the Constitution. With that, thank you.
Thank you very much, Peter. Questions, please. Identify yourselves. Professor Joseph Page from Georgetown University.
Am I on?
Yes.
Okay, my name is Joseph Page, and I'm a professor emeritus at Georgetown University Law Center. I'd like to thank Minister Dias Toffoli for his magisterial presentation as supplemented by Judge Massetti's comments. This was really illuminating. I'd like to ask Minister Dias Toffoli one brief, deceptively simple question, and that is hypothetical question, and that is if you were given the power to change one provision in the Brazilian Constitution to help the Supreme Judicial Tribunal perform its functions, what provision would you like to delete or add to the Constitution to help you face the challenges that you face now?
Então, se o senhor poderia modificar uma provisão só na Constituição para agilizar a justiça, qual seria?
Qual seria?
Yeah.
A very difficult question. Yes, a big challengers. I think what I did if I had this power. I think we need to change our electoral system because the great part of the problems in political government, it's because or named presidentialism of coalition. Because, for example, when in the 2014 elections, general elections, President Dilma was re-elected by the work part. The work part did only 68 seats in 513 seats. Almost 11% of the parliament. And others 27 parts did the other seats in the parliament. And how you could be the president with a so split parliament in Brazil. So if I could change it, I think the success of the countries like United States, Union Kingdom, Canada, New Zealand, for example, all of this country have the districtal, the county system, the districtal system, electoral system, not the proportional system.
But, Minister, is there anything that the Supreme Court of Brazil could do to affect that change? Is there anything that the justices in Brazil, the ministers, could do to get that debate going?
In the Supreme Court, we only could make something by provocation. We don't can make.
Someone has to raise it. They don't do it sua sponte.
Yes. It's impossible. But in the electoral court, because 3 of us goes to the electoral court for 4 years. I left the electoral court 1 month ago. I was the president until May 12. And when I was the electoral court president, I could go to the parliament and talk in public audiences about my opinions. And I give my opinions to change the law, to change the constitutions, but I don't have the power to do it by myself or the court by itself.
Thank you very much. Joel.
Minister, Joel Velasco with Albright Stonebridge Group, a non-lawyer in the audience, but a question that may not be hypothetical in a few weeks. In an area where the U.S. and Brazil converge in terms of the impeachment process. We're going to have the Brazilian Senate is going to have, I guess, the Chief Justice or the minister chairing the voting. And there's been indications that following that vote, should the President Rousseff lose and be removed from office, that she would appeal that decision of the Senate to the Supreme Court. In the U.S., this clearly is not even a possibility, but in Brazil, it sort of seems like it's still it is maybe a possibility. I would love to hear if you want to expound on your views on that at this point.
Yes, it's possible because the doors are open for all to claim at the judiciary branch in Brazil. There are a statement in our constitution that provides that everybody who has any kind of how can I say claim
Yeah.
could go to the judiciary branch. But the problem is, could the judiciary branch goes to the matter or only talk about the due process of law, the formal process. And I think that we only can talk about the formal process, not the material case that is the decision of the Senate.
Okay, thank you, Minister. Juliano Basile, Jornal Valor.
Juliano Basile from Valor Econômico. It's a pleasure to make a question for you here. I think I must add something that is different from Brazil to the United States, is that the Brazilian Supreme Court is very open to journalists as well. So we are able to argue the justice almost every day, and this is a real pleasure. I would like to make a question about Lava Jato, because this week Lava Jato went to the phase number 31. So I think that many people are going to contest the procedures of Lava Jato in the Supreme Court. So what do you think about these cases? Do you think that the Supreme Court can handle these cases involving Lava Jato? And I also would like to know your opinion about Judge Sérgio Moro, because he's coming to Washington, D.C. next week. So I'm very curious about it.
The car wash, or Lava Jato in Portuguese, it's investigation, big investigation that are going well. And when the defendants claim to the courts, if there are some kind wrong in the due process of law, of course, the higher courts could accept habeas corpus, for example, nullify some kind of decision that it's not under the Constitution. So, but in the most part of the investigations, I think it's going well, without problems. And there are a lot of people in jail. There are people that are already convicted in the Brazilian judiciary. And of course, the defendants will claim until the last higher that they could go.
Okay, and regarding your opinion on Judge Sérgio Moro.
Yes, it's important to say that there are two remarkable things about the Brazilian laws. Without the recent laws approved by the Congress, it was impossible to have the car wash investigation. It's important to say that even now, a lot of congressmen are being investigated by the Supreme Court in the car wash case. They approved 3 years ago the laws that permitted the collaborations of one of the involved in the crimes. So it's interesting because in the past, it's not a figure of one judge that changed the judiciary branch in Brazil. Of course not. You need laws to do it. And a lot of recent laws enacted by since Cardoso times, responsibility laws about budgets, after the laws about transparency, after the Lula that only appointed the Prosecutor General chosen by the members of the corporation, not by Lula itself, and with total independence to the prosecutor organism. So a lot of changes before this case, and of course the Mensalão case, when the Supreme Court convicted 25 businessmen and politicians. Of course, this empowered the judiciary branch in all Brazilian. So it's not a man that make a country. So he is doing well. I think he is doing well. And of course, when he don't do well, the defendant goes to the High Court, and the High Court resolves it. But it's not true that he changed the Brazilian history. Who changed the Brazilian history, in fact, is that now we have a civil society more powerful. Brazil is a country that the state birthed before the civil society. And now, after the 1988 constitutions, and because the times of the Constitutional Congress, 1986, 1987, the discussion after military times empowered the people with that bigger constitutions, but birthed a new society in Brazil. And all of this is a result of this empowerment of the people, of the civil society, and the press has, in fact, a big part of this with the total transparency that now we have in Brazil in democracy.
Paulo, may I make one comment about Sergio Moro? The difference that a judge in Brazil, a criminal judge, has as opposed to a judge in the United States is enormous. The criminal judge in Brazil can actually help conduct the investigation, can call witnesses on his own. In the United States, we don't do that. We leave everything in the hands of the prosecutor. We are purely reactive in the United States. It's true you need to get authorization from a judge here, as in Brazil, to do wiretaps and things like that. But Sergio Moro is doing a lot besides just judging cases. He's helping investigate cases, control the order, and so on. And he's got a lot of defendants he's dealing with. This is the highest of high-profile cases. I can't remember a case in the United States where there were so many defendants as he has. So it's an enormous challenge that he faces.
Yeah, we have a question here, another there. So, Julia, give it to the mic is here on your right.
I'd like to thank the Wilson Center for this Rule of Law initiative. My name is Christina Cerna, formerly with the OAS, now with Georgetown. For many people, human rights are the most important thing in a constitution. And there have been developments in Latin America, especially in Argentina and Mexico, where the judiciaries today and legal reforms consider the human rights from international human rights treaties together with the rights in the Constitution. And the Inter-American Court, through its doctrine of control of conventionality, now requires states to make sure that their laws comply with this new amalgam of constitutional and national rights. In Brazil, the situation seems to be a bit different. The Inter-American Court's judgment in the Araguaia or Gomes Lund case was answered by the Brazilian Supreme Court on the issue of the validity or the constitutionality of an amnesty law, where the Inter-American Court stated that it was unconstitutional, and then shortly thereafter, as I understand it, the Federal Constitutional Court or Supreme Court of Brazil stated that the law was constitutional. Could you comment on that, please?
Yes, I think the Supreme Court did well. And at that time, I was the Solicitor General, and I did a report to the Supreme Court, and I defended that the amnesty were for all, both the people that fight against the military government and the military that made torture at that time, because it was a pact, in fact, did in 1979 between the civil society of Brazil. And we could not, after more than 20 years, revoke this pact in a new generations and reopen problems that it's not so big that what occurs in other countries in the world or in the Latin America. The number of the died persons in Brazil is enormous less than in other countries in the Latin America. It's no more than 200 persons. So the problem in Brazil, it's not so big that it seems like abroad.
Yes,
Yes.
I think it will be the final question, the lady here.
Minister, thank you for the opportunity to make you this question. My name is Maria Elisa. I'm a Brazilian citizen, a student here in Washington. And I would like to hear your opinion on how the role of the Supreme Court should play in cases, and I'll be back to Lava Jato again, when a judge, he released an order to do a prevention prison of some kind of politician or whoever is involved in this in the investigation, and you think that it's the role of the Supreme Court interfere and cancel this order, like happened last week, for example? Because I think it's more to what he said, and I kind of agree with it, that one problem of Brazil is that we think that corruption is not that bad as like kill a person, and that prevention prison should only be applied when somebody kills someone, then we put them in prison to avoid another one. But in case of corruption, this is a too extreme measure, and corruption should be seen as bad as a killer. So I would like to hear what you think the Supreme Court should work on this, and what you think about that.
Yes, our Supreme Court has the power to hear all the habeas corpus of any people in Brazil. All the criminal defendants can go to the Supreme Court. And it's not true that only the rich men can go to the Supreme Court. This is a myth in Brazil, because we have a big staff of public defendants. And the numbers of the Superior Tribunal of Justice that takes care about the infra-constitutional level in our country, and the numbers of the Supreme Court shows that the most part of the habeas corpus are to the people that don't have a particularly lawyer. More than 50% of the habeas corpus that we decided in favor of the defendant are in case sometimes wrote by the defendant himself, the defendant himself. So what occurs is that generally in Brazil, nowadays, the prevent prisons, it became not exceptions, but a regular prison. And it's unconstitutional, because to go to the jail, you need to be before submit to a trial. And if you don't had the trial yet, how can you put you in jail? And the prevent provision by our laws is in case like the person don't have a residence, don't are collaborating with the investigation, or is making something against the investigation. So in this case, only in this case, you can put somebody in the prevent prison.
What about risk of flight? Fuga.
Nowadays, I in a decision, I talk about it. Nobody that try to
Flee.
flee
Yeah.
in Brazil are nowadays out of jail. All of them are
In jail.
in jail now.
And that's okay.
I think in this BBB world,
Mhm.
we live in a BBB world. Nobody can hire of the prisons. It's a true. We had a case of a female doctor that works with fertilizations, artificial fertilizations that rapid the woman that goes to her clinic, his clinic, and he was fly and he was captured 3 years ago. And in the Mensalon case, for example, one of the convicted had 2 nationalities, Brazilian and Italian, and he went to Italian, and Italian extradited him to Brazil. Even he has been Italian nationality. So nowadays, the fly is not a problem. Nobody can fly in the world today. Everybody in Brazil knows where I am now, because Juliano Basile and the other journalists will say for all Brazilians that I am in Washington, for example. It's impossible to ride in this world.
Yeah, I think her question was directly addressed. Obviously, the case recently, you were the rapporteur, right?
Yes.
Involving the former minister, Paulo Bernardo, and you decided.
And he never did nothing that we can suspect that he will hide.
Okay, she is obviously will hear, the case will be heard, etc. Well, with that, I would like to thank you very much, Minister Dias Toffoli, for your time, for joining us. Thank you very much, Peter, for once again collaborating with us. We will continue to do this. To our chairman, dear friend, Tony Harrington, to Therese, to Julia, to Michael, who have helped us put this together, to the people managing, monitoring, doing the video. Actually, at some point this morning, we had 4,300 people following this proceeding. We will put out a publication with the minister's presentation, as the transcript of Judge Massetti's statements and some of the questions. And so thank you very much. Continue to follow us. Again, if you're interested, Federal Judge Sergio Moro from Curitiba will be here to talk about handling corruption cases in Brazil. This will be on July the 16th. 14th, I'm sorry, Vive la France. July the 14th at 2 p.m. I think we have already a good number of responses to that event, and I am very grateful for that, and thank you again. I ask you to join me, please, in thanking Minister Dias Toffoli for having joined us.